Hello everyone, my name is Emmanuel Adebanjo, a legal intern at Harlem Solicitors. For the next few minutes, I'll be speaking on the legal rights and remedies of a telecommunication subscriber or consumer in Nigeria. First and foremost, who is a consumer? Section 167 of the Federal Competition and Consumer Protection Act 2018 defined a consumer as any individual who possesses or who purchases, uses, maintains, buys products or services for personal use and not for manufacture or resale. Section 157 of the Nigerian Communication Act 2003 also defines a consumer as any person who purchases or uses communication services. It should be noted that consumer can be used interchangeably with a customer or a subscriber. In essence, a consumer can also be referred to as a subscriber or a customer. Moving on, before a person can be entitled to the legal rights and remedies in telecommunications, it is very important for such a person to establish the following. One, that there is a transaction of sale between a buyer and a seller. Two, that the transaction sale was of goods, for goods and services. Three, that the sale was for a consideration. Four, that consideration was paid or partly paid, promised or partly promised. And finally, that use of such services or products are by the approval of the seller. Moving on, it is important for us to note that consumer protection is very important to prevent exploitation and also for quality of services. It is worthy of note that before a person can, before it can be said that the contract exists between a subscriber and a network provider, such a person must have acquired the SIM card, must have activated the SIM card, and the contract exists when he registered the SIM card in line with in compliance with directive of the Nigerian Communication Act. For instance, where Emmanuel buys and activates the SIM cards and recharges the SIM card in accordance with the pay-as-you-go system, a contract is consummated between him and network provider, in this case MTN, and such contract subsists till the end of his access period on MTN network, and it only lapses at the end of the access period. The access period varies between one network and another, but is usually within a period of 6 months. Such a contract can be automatically restored or revived once Emmanuel, in this case, is able to recharge his SIM card, but where he's unable to recharge before the end of MTN validity period, such the contract between him and MTN will be deemed to have been repudiated, and MTN is most likely going to block his SIM card. You should also note that the SIM block that is obtained in such an instance is different from the one that happens when a SIM card is misplaced. When you retrieve your SIM card, where you have to retain the former old number that you are using. Furthermore, it is important for us to note that there are certain rights that have been put in place for a telecommunication subscriber, and such rights they exist for everyone who is a subscriber, and a lot of persons they lack the information about such rights, and they make a lot of complaints that go unresolved. Specifically, Section 104, Paragraph A of the Nigerian Communication Act 2003 relates to consumer protection and quality of service standards, and places and obligations on network providers to one, meet such minimum quality of standards as the Nigerian Communications Commission may specify; two, deal reasonably with all consumers; and three, adequately attend to the consumer complaints. Moving on, in cases of undelivered text messages or dropped calls, where you are on a call with someone and the call is instantly dropped, and then your recharge card or your airtime is deducted for such a dropped call, or you send a text message to someone and the text message is not delivered, yet your airtime is deducted, the scenario can be likened or is tantamount to a failed consideration in the law of contracts, since the relationship that exists between you as the subscriber and MTN, in this case as the network provider, is contractual, and as such the principles of the law of contracts they apply with equal force, and so you are entitled, you have a right to recover all deducted airtime and call card. Moving on, we have in the provision of Section 105, subsection 2 of the Nigerian Communication Act 2003, every subscriber has Every subscriber has the right to an individual consumer code by the network providers. Also, by virtue of Section 108, subsection 3 of the same Nigerian Communication Act 2003, you have a right to a published tariff rate of your network service provider. I mean, no network provider is allowed or permitted to impose tariffs or charges on their customers or their subscribers. Furthermore, there are certain remedies that are available for you as a subscriber of in telecommunication sectors, and of all the rights that are available, the rights to redress can be referred to as the most important, and such rights can be said to be the hallmark of every consumer protection system. Section 73 of the Nigerian Communication Act 2003 provides for the power of the commission, the Nigerian Communications Commission, to resolve disputes between parties, now in this case the subscriber and the network provider. However, before resort is made to the commission, the Nigerian Communications Commission, provision of Section 74 stipulates that there must have been an attempt by both parties to resolve the dispute. Also, we can see from the provision of the NCC Dispute Resolution Guidelines 2004 that before resort is made to the commission, that both parties, the subscribers and the network providers, must meet and attempt to resolve the disputes before approaching court. Also, in the decided case of Abubakar and Nasamu, we can see the decision of the court where it was held that where a statute prescribes a mode of performing an action, only such a mode must be applied, otherwise there will be a nullity. In essence, before resort is made, before taking a telecommunication dispute to the court, parties must have exhausted the line of action that are stipulated by the Nigerian Communication Act. Otherwise, there will be a contravention of a condition precedent, and such a suit would be deemed premature or inefficient. And in essence, what we are trying to say is that when there is a dispute between the subscriber and the network provider, there should first be an attempt to resolve such a dispute, and where such an attempt is not successful, the dispute can be directed to the Nigerian Communications Commission, where it should be attended to by different negotiation means. Also, we can find the jurisdiction of the Federal High Court in Section 251 of the 1999 Constitution of the Federal Republic of Nigeria as amended. However, the exclusive jurisdiction of the Federal High Court, as provided for in Section 251 of the Constitution, does not extend to cases of breach of contracts and negligence. In essence, where MTN, for instance, negligently breached a contract between himself, between the company now and network provider MTN and a subscriber, the High Court has a right to hear and determine such a suit. So instead of referring such a case to the Federal High Court, since it is a case of a breach of contract or negligence, it is taken to the High Court. The High Court has the right to hear and determine such a suit. Thank you for listening to us. We hope that you enjoyed this session. For more information, you can kindly check up our website, harlemsolicitors.com, or you follow us on our social media networks on LinkedIn or Facebook or Instagram. Thank you very much.